I'm Michael DelSignore, Massachusetts OUI Lawyer, and today I want to talk about what happens when you come in to schedule an appointment with me to talk about a case. Well, if you're charged with OUI and your court date is on Monday, you'll come in over the weekend, we'll sit down and I'll basically explain the process. What I want you to understand is a few things. What's going to happen to your license, what the court process is like, and strategies for winning your case at trial. So what I'd like to do is give you an overview of everything that's going to happen in court so there are no surprises. I'll go through a generic intake with you too to see if there's any specific issues in your case. For example, if you're in the military, potentially I can get the whole case diverted. So one of the things I like to cover is license consequences. I like to tell you when you'll be able to get your license, and that'll depend on whether you took or refused a breath test. Next thing we'll cover is steps in the court process. The arraignment is your first day in court. No one expects you to know how you want to handle the case at that point. In other words, you don't have the police report. So once we get the police report, we'll review all the evidence, and then we'll decide if you want, you might resolve the case. In other words, if the case is very strong and there's not a good defense, you could resolve the case down the road or even very shortly after the arraignment. The court will generally schedule your court date about 4 to 6 weeks after your arraignment. However, if it turns out that you want to resolve your case, we can always bring you back to court quicker to do that. Hopefully you'll want to fight the case, and in many cases that'll be the best strategy. So after your arraignment, you'll get a pretrial date. That allows us to get all of the evidence that the government has. There might be video evidence. They don't have that on the first date. There might be other documents, or there might be evidence that we might want to acquire, like medical records. So at the pretrial, generally that's all done. Then the case will take 1 or 2 tracks. Let's say you told the officer you had 5 or 6 beers. We might want to get that suppressed in your case. So we might do a motion hearing to try to limit the evidence, and that's either excluding a statement that you made that's hurtful to the case, excluding evidence, say there's alcohol in the car. So motion hearings attempt to limit their evidence. Finally, once a motion is done, or if there's no motion, then we set the case up for trial. When we set it up for trial, we'll go over your version of the case, we'll have reviewed the scene, we'll have talked about the case quite a bit at that point, and then we'll have a meeting prior to the trial, or basically a trial strategy meeting where I discuss whether you're going to testify or not. In many cases you won't testify, but in some I can put you on the stand. I think many are very scared and nervous about testifying, but I found is that, one, the cross-examinations of the government isn't as deadly as you'll expect. My cross-examination of you in the office will be a lot more difficult than what you'll actually get in court. 2, people I think are overly nervous. They assume a trial's in front of 40 or 50 people. These trials in district court are in front of a 6-person jury. Typically, the courts are empty. They're not as public as I think people have the perception that they might be. So we'll kind of go over the court process, get a realistic view of what a trial in district court is like, and then I'll explain to you my strategies of defending the case, what techniques I'll use, and how I'll cross-examine the officer to get the point that you weren't under the influence of alcohol. You know, some themes I like to use: you were just drinking socially, it was an accident but you weren't under the influence, it was a mistake in driving. So there's a lot of themes that we use to try to communicate and convey to the jury that this wasn't somebody that had too much to drink. Finally, I'll give you a copy of a book I wrote that explains the law and let you take this home. Once you speak to me, there's no pressure. You can hire me then if you want. You can take some time to think about it. We've handled these cases for many people. We have online reviews. You can check us out. We're very busy, well known in the court, and I'd be happy to talk to you about your case. And after you do so, most people feel better about the process. They're not as nervous. They're not as stressed about what's going to happen because they have answers to the questions. So if you have any questions, feel free to contact me, talk over the phone, or come into the office.